Welcome again to the Melling Law YouTube channel, where we talk about different estate planning topics relevant to Utahns. Today, we're right toward the end of February, so we're talking about retirement accounts. A lot of people this time of year are meeting with their financial advisors, trying to put together their tax strategies for the new year. So a lot of people are thinking about these retirement accounts, whether it's a simple brokerage account that holds different types of investments, or maybe it's some kind of one of these accounts with tax implications like a 401k, 403b, IRA, Roth IRA. Any of those kinds of accounts, they take special consideration in estate planning. We don't necessarily want to put everything in the trust, especially when it comes to some of these kinds of accounts. So in a nutshell, let's start with like a bank account. Bank accounts, savings accounts, those, if you have a trust, are almost always going to be pay on death to the trust for middle class families. If you have a brokerage account, one of these accounts that is not held in one of these accounts that has certain types of tax benefits or a different type of tax allocation, then usually these brokerage accounts are also going to be pay on death to the trust unless your financial advisor says otherwise. Because if it's a simple account that's holding pretty basic types of investments like most mutual funds, stocks, bonds, money market accounts, any kind of account that is not annuitized or in one of these types of tax accounts, tax deferred accounts, then almost always we're going to just have that pay on death to the trust. Now, these other accounts, if it's a 401k, 403b, IRA, then they're a little bit different in estate planning, and usually I advise you to talk to your financial advisor and your estate planning attorney on a case-by-case basis to see what is the best option. Most financial advisors will advise you to have these types of accounts pay on death directly to a beneficiary rather than to a trust. And that's because there are certain tax advantages to doing it that way. However, from an estate planning standpoint, we're always worried, what if something happens to one of these beneficiaries, or what if they're not quite old enough to manage these funds, and we want to stretch out that time at which they can actually access these funds. What if they become chronically intoxicated or incarcerated? Do we want to still have them receiving these funds? With the beneficiary designation, we don't have control over that. So that's kind of where an estate planning attorney comes in for those types of scenarios. Is we look at the family dynamic, we look at the other assets available to these beneficiaries, and we figure out how do we want to allocate these funds in the way that's best going to fit the family's goals and objectives. And we do work closely with the financial advisors in that scenario just to make sure that nothing is missed. So in summary, it's springtime's approaching. A lot of people are thinking about these retirement accounts. Just be extra careful in your estate plan on where they're going pay on death, because like I said, these bank accounts, these brokerage accounts, usually we want them held by the trust or pay on death to the trust. With these different types of tax deferred accounts or retirement accounts, or different types of financial products that don't necessarily fit that standard mold, we want to be a little bit careful. Maybe have them pay on death directly to the trust, or pay on death directly to the beneficiaries, or some kind of mix depending on the family dynamic. But that's where you do want to work closely with your financial advisor and your estate planning attorney to determine that. So thanks for listening this week, and join us next week. You can always reach us at mellinglaw.com or at 435-572-0807.